Good afternoon to everyone jumping in. We are going to, obviously it's still a little bit before 1 o'clock. We're going to wait a little bit and probably about 1:05 get rolling. So if you got anything to do, go ahead and do that, and then be ready about 1:05. I'll jump in here and there just to make sure we're still alive, and then we'll be set. Morning all, afternoon all. Thanks for jumping in. We are going to get started about 1:05, get kind of some stragglers, a little bit of time to get in. We had about 50 people register for this, and we've got about 30 in here now, so we're just going to wait for kind of the rest to come in. But if you got something to do, we've got 5 minutes before we're going to get kicked off. It looks like we've got about 80% of the people in here now. So Jeremy and Gary, we might get rolling. Welcome everyone to the latest installment of the TXWA webinar series. I'll just make a few quick introduction points and then hand it over to JP to introduce our speaker today. Thank you first for jumping in to not only this webinar, but the last one. We appreciate everyone kind of coming back in after we had some technical difficulties. We're got our fingers crossed that that's not going to happen again this week. As you probably saw in the emails, we've got another one next Wednesday to look out for with our partners in Pathwave. So please jump into that one if you can. A few quick notes. We do have a chat feature that exists within this software. It's in the toolbar that it is there. Go ahead and send that one to all of the panelists and organizers. We'll compile it all at the end and ask Gary, and we should be good to go. We will be recording this. Webinar. It will be available afterwards on the webinars tab on the TXWA webpage. If you have any questions that didn't get answered, please reach out to membership or networking, and we'll make sure to get those answered afterwards. Other than that, unless I missed anything, JB, I'll hand it over to you and we'll get rolling.
Got it. Thanks, Ben. So good afternoon. For those of you that don't know me, my name is Jeremy Baldwin. I'm with Diamond Communications. I'm also the Vice President of the Texas Wireless Association. Kind of like Ben said, today is the fourth webinar and kind of an educational series we put together, I don't know, a little over a year or so ago, trying to bring some value to the membership and also our sponsors, you know, do some educational stuff that probably in the past hasn't been done. Texas Wireless today, we're happy to have Gary Pennington of Pennington Law Firm with us. Gary's got over 30 years of experience in the legal and telecom field. And his legal experience has allowed him to help clients navigate aspects of the telecom legal environment in a confident and consistent manner. As a side note, he's also a dog person, has a couple of Weimer honors. I probably butchered that, but I know we got a lot of TXWA folks out there that are dog people. We usually have a calendar that comes out every year put on by one of our sponsors randomly enough. But anyways, Gary's here today to talk about drafting communication leases and some points and tips that maybe you can do to save time and avoid some pitfalls as you kind of do your day-to-day business. So with that, I'll kind of pass this off to Gary and we'll get this thing rolling. See if we can learn something today.
Well, thanks, Jeremy, and thanks to the Texas Wireless Association for having me here today. It's an honor. I can't see who's on the other side of the screen, so for those of you I know, hello, it's good to see you again, or maybe for you to see me. For those of you who don't know me, I look forward to getting to know you later maybe and learn more about you. Just a little bit about me. I live in Beaufort, South Carolina now. Been here for about 4.5 years. I was in Columbia, South Carolina for over 30 years, where I had a firm that had a national practice. We had about, at the maximum day, probably 50 people, 21 attorneys, and we did about 35,000 wireless projects across the United States, predominantly representing what is now Verizon Wireless, Crown Castle, T-Mobile, indirectly AT&T through build-to-suits. So there's not much we haven't seen or that I haven't seen, and it's been a good experience. There's someone reminded me recently that, you know, 1 year in wireless is like a dog's life. It's really like 7 years because it's so pressure oriented and, you know, let's get this done now. And I've worked on a lot of big projects for headquarters, M&A projects, all the way down to, you know, large acquisitions like the Alcatel acquisition and disposition of assets like the sale of the paging companies and sale of towers, and representing Crown when it was acquiring all of its towers in the earlier days from the carriers. And just, you know, those big projects that keep you up all night for weeks on end. You want to pull your hair out before you're done. But, you know, we've touched on a lot of different things throughout my career, from the basic lease to zoning to, you know, the most complicated thing I've done recently was to draft a multi-carrier DAS license agreement for an NFL stadium owner for a new DAS and a new stadium that's going to be anchored by a carrier. And I'd seen plenty of those agreements before, but everything I'd seen was just terrible. And, you know, I think it took me like 20 hours to draft that agreement, but it took all the cumulative experiences that I have had over the years to be able to sit down and put together a document like that, where there are, you know, millions of dollars involved. So lots of experience. I'm a lot smaller now than I used to be, but I'm still active. I don't represent any carriers any longer. From time to time, I do represent a smaller tower company that's in the region that needs some help with zoning. Don't really draft any land leases, tower leases anymore. That's really not what I really want to focus on. You know, in my early days, I drafted a lot of the pro forma agreements for the carriers and the tower companies, a lot of the MLAs, negotiated MLAs, and the 20 amendments thereafter. But anyway, enough about me. Let's go ahead and get started. Don't worry about taking notes. At the end of the presentation, I'll give you my contact information, and I can provide to you the deck that you'll see today, but as well, sort of a more detailed analyses of the terms that we're going to be discussing. So today's topic is going to be about drafting communications leases, and predominantly what we're talking about are wireless communications leases. But you know, a lot of these provisions, these terms, these concepts carry over to many things telecom related. So you know, before you start drafting a lease, think about what it is you're trying to accomplish, because I've seen so many bad leases in the past, and the transactions I've viewed either after the fact or during the fact, where the drafter really never stopped to think about, okay, do I have the right form in my hand? How old is this form? Who was it created by? Was it created by a tower company for a tower company build to suit a build? Was it created by a carrier? Was it for a tower? Was it ground lease? Was it a building and rooftop deal? Was it an in-building deal? Just any number of things. And you know, some of the agreements out there that you see are better than others. You know, my approach has always been, at least on the ground lease side, to keep it simplistic, to get deals done quicker, and not put complicated documents in front of, you know, just regular folks who really are not going to understand. And most of the initial interaction with the landowner comes from what we call a site acquisition person, SATAC, not somebody that works directly for a tower company or a carrier. And they're going to want to build trust. They're going to want to trust you, and you're going to have to work hard to build their trust. And you're going to have to be able to explain to them the terms in this agreement. Some of you on the line may be an attorney. Some of you aren't. Some of you have real estate licenses. Some of you do not. I would caution you to be aware of the laws in the state in which you're practicing and what they require in terms of negotiating and/or drafting leases of any nature. I think more and more today I see that there are fewer attorneys involved in these transactions. Back in the beginning, it was, you know, like the gold rush, you know, get it done, get it done, get it done. You know, we were doing 4,000 projects a year, you know, getting new territory where we had to turn 500 sites on air in 18 months. So yeah, the carriers were really anxious and in a hurry then to get things done and didn't mind paying lawyers. But as we all know, that in the industry over the years, that they don't really pay outside counsel that much money anymore to be involved, and they look more to turnkey operators to do everything, including the legal work. But think about the technology type. You know, what are we accomplishing here? Is this just a simple build for a tower that carriers will co-locate on? Is it an in-building? Is it going to be a small cell? Is it going to be indoor DAS, outdoor DAS? You know, the technology involved will have a big impact on how the agreement is drafted and the various components of the agreement. So it's incumbent upon all of you to make sure that you're familiar with the technologies, stay abreast of them, go to the conferences, you know, read the emails that you get in your inbox every day, read the white papers. You have to stay on top of the technology as it evolves, because it evolves so quickly. It's hard even for me at times to keep my mind wrapped up around it all and how it all works together in the whole ecosystem of what we call wireless. You know, think about the structure type. Is this a guide tower? Is it going to be a monopole? Is it going to be some type of disguised tower, if you will? Is it a building and rooftop? All those things. Is it a water tank? All of those things have different components to them that will impact how you draft the lease. Who's your client? Who are you representing? Are you representing a carrier or an infrastructure owner? And I say that word infrastructure owner because I don't even think there is a true tower company anymore. Maybe there are, but most of the larger ones, they call themselves, you know, like digital asset infrastructure owners. I don't think they want to be coined as a tower company, it puts them in too small of a box. But if you're representing a carrier, the way you draft the agreement is going to be a bit different than it would be if you are a tower company. However, I've seen this mistake many times. If you are representing a carrier, you need to draft that agreement as if that tower is going to be sold at some point, and then it's going to be managed and owned by an infrastructure owner. So those terms will somewhat transition because the needs of a carrier and the needs of an infrastructure owner are not the same. And the opposite would be true as well. If you're a tower owner or representing a tower owner, you need to be thinking about, okay, I don't need to draft the lease just for the benefit of the tower owner. I need to draft it from the benefit of the carriers that will be co-locating on the tower to ensure that they get equal, or at least, all of the bundle of rights that they need in the lease document, as opposed to just the tower owner. Future assignment itself sort of touched on that already. Be thinking about, what.
I think you're bringing up some good points, Gary, there where you're talking about, being able to assign it, or, picking up the right template. I think, I'm sure we've all seen it. Site Act works a site, and maybe it was a rooftop, and then they wind up going to another candidate across the street, and you see a lot of copy paste errors. I think that's probably, kind of a critical thing, is to kind of think about, what am I doing, where am I doing it, why am I doing it, and who am I doing it for, and kind of getting your base template, right, and understanding where you are. Maybe a landowner fell off, something happened, and you had to work with another candidate. Am I doing the right deal? Anyways, some good points.
Don't draft your next lease based off your last lease. Start from a blank pro forma form so that you don't overlook some change you made in the last deal that you don't want in this deal. That's a big mistake people make. Don't contaminate your base form. Protect it at all costs. Obviously, if I'm representing a landlord, I've got one opinion. If I'm representing a tenant, I've got another. So that will have a huge impact. Obviously, you want the lease to be balanced so it gets signed. At least commercial leasing is difficult these days. Even in the wireless world, it's getting more complicated. I do a lot of commercial real estate as well, representing, large landlords and/or tenants and large commercial office Class A buildings and larger metropolitan areas. And just last month, I had 3 deals I was working on, and every one of the leases was 80 pages long with the exhibits, single space, 11 font, Times New Roman. Now think about how long it takes to get through something like that. It makes you wonder sometimes, do I really want to be a lawyer? But it's these landlords are difficult. So yeah, it's getting complicated. A lease or an option. That's always been a big issue of discussion. Do you want to option the property, or do you want to go ahead and lease it? We'll talk a little bit more about commencement dates later, but the general rule of thumb for me is, if I'm not going to build that tower within 2 years, I'm not going to lease. I'm going to get an option, 1 year option with the second renewal term for 1 year, and pay some amount of consideration. Don't tie up the property with a long-term lease where consideration may become an issue, and potentially bad faith claims if you don't exercise if you don't move forward with the construction of the tower. So anyway, all of that sort of circles back to the form of agreement, taking into account these various considerations, and there are many more. I've just tried to consolidate these. So let's move on then. Parties defined. Now you would think this would be the simplest blank to fill in your form, but it's not. It's probably one of the hardest things to fill in the form, because people get it wrong so much. So you'll have various forms of information coming into you. As an attorney, we used to get skip packages where the site acquisition had put together the skip 10 or 11 pages, property owner name, address, tax map number, zoning classification, zoning process, aerial photographs of the site, things of that nature, but I never trusted them. They may or may not have had a vesting deed attached. So, you want to make sure that you're dealing with the right party. Obviously, if you're representing a carrier, make sure you have the right licensed entity. For example, Verizon has Cellco partnership in most areas, but I bet there's probably across the United States, 500 different licensees. It's the same with T-Mobile. Some of that's been consolidated, but you got to make sure you got the right carrier. or you don't have a valid agreement. You know, if you don't have a skip, or even if you do, go to the tax records. All this information is online and it's free. You can easily pull up a tax record, a tax map, but you can't rely on that wholeheartedly. At some point, you're going to have to order a title search. I recommend, and it's different in every state, but most states, typically a 60-year commercial title search that gives you the chain of title, all the exceptions to title, the vesting deed, who the property is titled in, so on and so forth. That's very important. You know, I always like to have a title search in hand before I actually draft a lease. Some clients don't like that. You know, they want to get the lease signed at the kitchen table the day they make contact with the landlord. You know, I've never lost many deals because I waited and did things the right way. But you know, that really depends on the sophistication of the site acquisition agent to make sure that he's holding the hand or she is holding the hand of that property owner and keeping them comfortable until that lease is ready to be executed. You know, there are some complex ownership issues out there. In my 30 years, I've only seen 2 lawsuits on leases that I've drafted, and they both involved condominiums, horizontal owner association, HOAs. And it's not that we did the lease wrong or had the wrong party. It's just historically, you know, once the HOA is turned over to from the developer to the unit owners, it's a nightmare, and they're not happy with the developer, and they want to sue him. And one way they sue him is to, okay, well, you got that lease on the rooftop. You know, we should be getting that revenue, not you. So, you know, HOAs and condominiums are probably one of the more complex because you've got to review the master deed, you've got to review the covenants and the bylaws to see who actually has the rights to lease space on the rooftop of the building or any other place in the building, common elements, special common elements. It gets really complicated sometimes and can get you in a lawsuit in a heartbeat. And you know, beyond the party type, I've got additional language I'll put in any lease that has an HOA involved where they give me reps and warranties and an indemnification in regard to their ability to enter into an authority to enter into the agreement. And in some cases, I'll actually have the attorney representing the HOA give me an opinion letter indicating that he is of the opinion, based on his review of those documents, that they have the ability and or authority to enter into the agreement. And then it's a matter of, well, who approves it? Does the board have the right to do it, or the president, or does the association as a whole have to vote on it? And if so, how many unit owners have to vote in favor of it? It's complicated. Another complicated owner would be a trust. You know, if there's a trust involved, you want to make sure you get a copy of the trust. You want to make sure they review the terms of the trust to see what the powers of the trustee are. You want to make sure that there's a certificate of trust recorded in the county title records. Another complicated entity would be a political subdivision. In the state of South Carolina, we have cities, municipalities, we have counties, but we have all these special purpose districts, if you will, that were created by legislation dealing specifically with that Beaufort Jasper Water Sewer Authority entity. And sometimes you may have to look all the way back to the statute that created the entity to determine what their authority and what their power is in regards to the lease of space on that water tank that's been funded by public dollars. Highly complex. One of the most difficult are religious organizations. You know, every religion has their own form of governance. I grew up Southern Baptist, independent Southern Baptist. Most Southern Baptist churches have their own articles, their own bylaws, you know, their process for approval of leases, who signs those leases, having a called meeting, having a congregational vote. Or then it gets more complicated. Like, for example, in the Methodist Church, you know, there are various levels of administration. And I got burned on that one time too. I was doing a deal in Columbia, replacing a cupola on a Methodist church, dealing with the church staff. Oh, this is all we need. You know, the deacons have approved this, the church has approved it. And then the last minute, we found out that there was this higher level of Methodist entity that had to approve the lease. And then there was a daycare at the church and the moms found out about it. and all hell broke loose. We had a room full of about 200 angry people. I flew in an expert witness on RF safety. I could not convince those people, so the church leadership said we can't do this. So $40,000 into A&E costs and legal, probably another 20 in legal fees. The deal was dead, and they really needed coverage in that area. They still don't have it today. That's probably been 20 years ago.
So if you're dealing with churches, basically you need to kind of, dig in a little bit deeper and maybe, do some research, talk to some higher level folks inside the church, because maybe the person you're talking to, a lot of times there's the older kind of bishop or something like that in the church. It's kind of managing this stuff, and maybe the preacher's not involved.
Right.
You may need to get more people involved, elders or whatever, to dig into it. Maybe this is a newer guy that doesn't know, and may not have the authority to do something he thinks he does. So it's just, you need to be careful. It makes sense when dealing with a religious organization.
But ultimately, you're going to want their articles, their bylaws, their rules of governance. Like, I'm a deacon in the Presbyterian church, and I had to take this class on their, governance rules. It's incredible. The extent, there's probably 3 levels of hierarchy that would have to approve a Presbyterian church lease. And anyway, the state law requirements, be aware of that. For example, in North Carolina, even if the property is in one spouse's name, the other spouse has to sign as well. Not to make the document legal, but to protect you on the back end and probate, because if the spouse that owns the property dies and signed the lease, didn't have his spouse sign, then there would be a potential claim in the estate to avoid the lease. So that's tricky. So that's really something you got to be aware of. All right, I'm gonna move on. So effective date versus commencement date. You think this would be pretty simple. It's not. Effective date, you need always to have an effective date, that being the last signature date on the document. That way it's a binding legal document. Now, your commencement date's another issue, and people struggle with this. Oh, how do we commence the lease? Well, 2 things you want to preserve. You want to preserve term, so you don't want the clock to start ticking too soon, and you don't want to start paying rent until you actually start construction. There's some bad actors out there that do leases, open-ended commencement dates, no drop dead dates, no obligations, or to start construction by a certain date. I would say it's unethical. It's mostly these one-off guys that come across rings somehow magically, where they know a carrier is coming and they go out and lock up the property in the heart of the search ring, not knowing if or when the carrier will actually come. And then they strong arm the carrier to enter into a colocation agreement, and they build the tower then. Just to give you an example of that, I had a case about 2 years ago where it was over 1,000 acre property where they did like off-road riding and things of that nature. And the owner had signed one of these leases like 5 years previously for a 1 acre site in the middle of it, and an access easement. It was a terrible lease. It was by a tower company using an old Sprint carrier form. So it was really screwed up, but there was really no way out of that lease because the commencement date was open-ended, and this guy had been paid 1 dime, no consideration. But I was able to resolve the issue. I mean, this was like over a $10 million deal. So we basically subdivided out that parcel and sold everything else around it. I was able to get that approved by the county and save that deal. But if you're going to have an open-ended commencement date, if you're a tower company, you're building a tower and you don't know when it's going to be built, then I would highly recommend 2 things. 1, pay some nominal consideration at lease execution, but put a drop dead date in there. Don't leave it open forever. If you don't know when, if you're going to build it, do an option agreement. I've done so many leases over the years, and I can't tell you how many telephone calls I get every week from landowners all across the country. Mr. Pennington, I've got this letter in my file. It's got your name on it. And we did this lease with whoever, Bell Atlantic, Verizon, whatever entity, and we can't get a hold of them. We've got a recorded memorandum, but they never built a tower, and we need to get it released. And I don't represent Verizon anymore, and evidently they have a landlord 1-800 number. And if there's anyone on the Verizon call listening, maybe take heart, answer those calls, because I can't help these people. But you know, they've got these signed leases and recorded memoranda encumbering the title to their property where there was a decision made not to build the tower. And these people are stuck, and that's not fair. Anyway, so nominal consideration, drop dead dates. You know, so what should the trigger for the commencement date be? One of the things that my great hero, Bernadette Fiala, lease administration at Verizon HQ taught me was, Gary, you have to draft the lease so that it can be easily administered. So, you know, I don't know what it is today, but then they had over 30 people sitting in a room, you know, processing new leases into the system. They needed to be able to abstract those leases, put them in the system, automate payments, things of that nature. So always think about lease administration, like, okay, am I drafting this so that it's going to be understandable when this non-lawyer person tries to enter the lease into the system? So if they don't get it right, then the payment doesn't go out, or the renewal is not done, or there's a problem later in time. So keep that in mind. You know, the simplest way I think to commence a lease is base it on the building permit, not the start of construction. That's a very nebulous term. When did you start construction? What does construction look like? Anyway, so everybody knows when a building permit is issued, and typically if I'm pulling a building permit, that capital is committed. And once I pull it, it's got a shelf life. It's going to expire if I don't start construction within a certain date. And typically I would say to avoid partial prorations, the first day of the month following the date of the month that the permit was issued. So it's the first day of the month, and that makes it so much easier. You might also consider putting in your lease that the first payment will be paid, you know, 45 days after the commencement date and not the first day of the month, because there's no way that there's going to be, you know, the administrative power to enter that lease and get the check issued that soon. So there needs to be some time. If you don't do that, you're not managing your property owner's expectation, and they're not going to get that check, that first check, that very important first check. And then you're really off to a bad start in the relationship, and you don't want that. So think about those kind of things. Lease premises. Now this is important as well. I mean, all these things are important, and you, on the surface, you think they'd be simple, but you know, as you look through all these requirements, it's not necessarily true. It's probably one of the most crucial provisions, you know, in the document. So, you know, if it's a land lease or something of that nature, a water tank or a co-location, typically I would like to have a survey, at least a draft survey in my hand, so I know exactly what's being leased, how big it is, what the shape of it's going to be like, what kind of tower I'm dealing with, what the topography of the land is going to be, how the utilities are going to get there in terms of connectivity, things of that nature. One of the things I hate to see is I get a lease in my hands and it's got a hand-drawn site sketch attached to it. That's useless. That doesn't mean, it's not even enforceable, really, to be honest with you. Even if you got a tax map number and a description of the overall property attached, that hand-drawn sketch is useless. Some companies do that, and then when they do the memorandum of lease, they'll have a, you know, they'll treat that as an amendment to the original lease with the meets and bounds description of the lease premises and a survey attached. I would advise you that it's always best practices to, just like with the title search, to have at least a draft survey in hand when you do the first draft of the lease, to make sure that you're covering everything. Because once you send something to the property owner, you don't want to have to go back time and time again. Oh, well, we need to change this, because every time you go back, he's going to want, or she's going to want, or they're going to want something else from you. And you don't want to have to fight that battle. You know, it's not your job to negotiate financial terms after they've been agreed to initially. Your job is to get the lease executed in the right fashion. And I know a lot of times that with SITAC, you know, there are milestones, one of those milestones being an executed lease. So really you're only thinking, oh, I get this lease executed, get this lease executed. Well, you can get a lease executed, but you're just buying yourself problems and headaches on the back end that you're not going to get paid to fix. Okay, you're not. You're going to do it for free. So think about those things. You You know, obviously the lease premises will vary, you know, for a land lease, you know, 100 by 100. If it's a monopole or a guide tower, it's going to be different. Like a lot of people don't realize that, okay, it's a guide tower. How do we do that? 3 ways. You can lease a 5-acre circle depending upon the, you know, the length of the guy wires. Typically, you got to go beyond those, or you can do what you can lease a star, you know, like a square in the middle with 3 fingers, if you will, for the guy wire and guy wire anchors, or you can lease the square in the middle and get easements for the guy wires. I don't recommend that third approach. I don't recommend the circle either. I would do, you know, the star approach to minimize the amount of land that you're leasing, that you're responsible for, that you have liability for, that you may have to pay taxes on, all of the above. If it's a building and rooftop, obviously you're going to have different components. You want to make sure that the leased premises has everything necessary for connectivity on the rooftop, for the antennas, on the rooftop for the cabling, connecting points if you're going inside for your equipment, or if the equipment's on the rooftop. You're going to want connectivity going to the ground if you got to get to the ground for gas or for a generator. You just want to make sure that you have all the rights you need, so that you don't have to go back and ask for them later. You need to look at the zoning requirements. You know, some zoning ordinances have minimum space that you have to lease. They have buffer requirements. They have landscape requirements. You know, all those kind of things that could impact the amount of space that you need to lease, that you need to make sure that you capture. You know,
setbacks is one that comes up underneath there too. I mean, I've seen leases over the years, you know, where somebody's leased at 75 by 75 in a corner that was never going to be zonable. It's leased, but it was never going to happen because you got, you know, 2 to 1 or 3 to 1 or whatever setback, and you know, it's never going to happen. You pin it in the corner. I mean, the landowner may want it there. You probably may need to do a little more due diligence on the zoning end of things and trying to do a better job explaining to the owner what you need, rather than, like you said, coming back later and saying, hey, this guy's got a 5-acre tract. We can't put it in the corner of his pasture. We got to put it right in the middle of it. You know, it's a bigger consideration for the landowner.
You know, some jurisdictions measure setbacks from the property line. Some measure them from the lease line. And if they're measuring from the lease line, you got a problem because you're leasing a lot of property. You know, some jurisdictions require fall zone. You know, you don't want to lease all that area. You want to pay for that once, that fall zone or that buffer zone. You want to pay for that once. You don't want that to be a recurring monthly or annual payment that escalates every year, every 5 years, and then just pay lease payments for what you're actually using. And then at the end for the lease premises, make sure that, you know, you capture any changes that have been made throughout the leasing process and the final lease, the memorandum of lease, the SNDA, which is a subordination, non-disturbance, and a torment agreement in the survey, to make sure everything's accurate and consistent. You don't want inaccuracies. I see that all the time too. Anyway, so this is access and easements, and I'm probably going a little too slow. I'm gonna speed up. You know, this is a crucial term as well. And, you know, there are probably like 50 lease terms I could have talked to you about. I think I sort of focused on 10 or 12, and we may not make it all the way through, but I tried to focus on the things that I think are more important, you know, and, you know, access and easements are just right up there at the top. And when I've taught a lot of attorneys. So, you know, I taught not only my own attorneys, but when Verizon was created back around 2000, they went from an East Coast company to almost coast to coast company. And at least for the Southeast and in the middle of the country, including Texas, I was responsible for training all the new lawyers that were coming on board from the other carriers that were required. And that was quite a task, but I didn't say that at the beginning, but I've done a lot of sites in Texas, by the way, and Oklahoma and Louisiana, and Arkansas over the years. So I know that area well, and probably have some friends. Richard, I think you're on today. Hey, how you doing, Richard Taylor? But when it comes to access easements, here's rule number 1. Don't let their problem become your problem. And I've had attorneys that broke that rule a couple of times that required me to spend hours on hours trying to fix access issues at my own cost because I wasn't going to charge my client for the mistake that we made. It wasn't our mistake in the beginning, but their problem became our problem. It's tricky. So, you know, you got to have a good survey. You need to look at all the maps online you can find. There's so much good GIS information, Google Earth. The GIS information is really good, but you really need that surveyor to put in writing on that survey with his seal, you know, is this a public road or a private road? Unfortunately, sometimes it's not clear. You contact the county or the city and they don't even know. Sometimes they've got these antiquated databases, and we're not building towers in cities all the time. We're out in country landscapes and on the top of mountains and things of that nature. And, you know, you need an access easement that touches upon that right of way. And that needs to be a public right of way. If it's a private road, then, you know, all the red flags go up. Okay, well, if it's a private road, if it's not on the property of the guy I'm leasing from, then what rights does he have to use that road himself? And what rights does he have to grant to my client the right to use that road? And then what rights will I have to allow my subtenants to use that road? And that gets hard because it's not always clear. Because even if the landowner has some rights into the private road to grant access, he may not have the full bundle of rights. Because in most states, a landowner, even though it's in his deed or in an easement agreement, you know, he has some rights. He may not have sufficient rights to change the scope of the easement or the use of the easement. And the scope of the easement means, okay, this was for ingress and egress only, and for 3 people that live on this private road. Now, it's for ingress and egress, and utilities, because we're going to trench in utilities. And it doesn't say that, so we change the scope, and we're going to have heavy trucks, equipment, cranes coming in and out. We're going to have multiple carriers coming in and out in their crews. So you change the scope, and you've
kind of changed it from a residential venture to a commercial venture without in one step. I mean, so it's, you know, if you're probably on a dirt road or a gravel road or something like that, and you know, and talk to the landowner. Maybe you got to talk to one of the landowner's neighbors or something. I mean, just get as much information as you can, because it can be a bear trap.
Yeah, you got to, if you're crossing other properties too, even if it is a private road, you better do a title search on every property that you cross, because you want to make sure there are no encumbrances on that property, like a mortgage or some covenant restriction that would prevent the use of the road. Or if there is a mortgage, you got to get an SNDA, or if there's a consent requirement, or there may be a maintenance agreement in play that's going to add another financial burden on your client for the use of the road and to actually maintain the road potentially. So it's difficult, but make sure it's buildable. I've had sites before, and this is crazy, and up in North Carolina where a surveyor drew in, there was an access issue. So without going back to the site, they went in and drew a new easement over another property that we acquired an easement over. But when they went out there and looked at it, it was like such a steep terrain, and it wasn't buildable. You couldn't build a road there, so it was useless, a waste of money. You know, probably $30,000 chasing that rabbit. I mean, it eventually got resolved. I think it was up near Balsam Mountain. It eventually got resolved. Railroad crossings, oh, you're talking about a headache. I mean, there are 2 kinds of railroad crossings. Private railroad crossings, the worst. Public railroad crossings. It's the private railroad crossings that cause the heartache, because first of all, you're never going to find the document of record that created the easement or right of the railroad company to build the railroad. And railroad companies are hard to deal with. They really don't care. They don't care. I think I saw in the news today where one of the carriers was getting sued by 2 of the railroads for installing or crossing railroad tracks with, you know, broadband connectivity. So they're going to go to court and litigate that. But yeah, this can be a showstopper. And if you get a site and there's a railroad crossing involved, you know, where there are no cross arms, it's just like in a field, and there's a you know, like pavement on either side where you can drive over the railroad tracks. Go find another site, because you're going to waste about a year trying to negotiate a license agreement with the railroad company with onerous terms. It's not going to be good. And one of the things I've done in the past is, if I were able to get the license agreement, I would still, you know, look at the GIS maps and try to get an alternative easement even if I didn't build a road over an alternative property to an alternative right of way. So that in the event the railroad canceled my license agreement, which they can do at will, I had somewhere I could go build a new road. So think about that. You know, mountain sites, private roads, property maintenance agreements, oh, nightmares. I mean, nightmare on nightmare. You better make sure you have a good surveyor who knows how to survey in the mountains. It's different. It's different. And you better make sure you got a really good title search company that's doing that title search. You can put all this together for you. Otherwise, you're going to have a problem. As soon as you start building that road, your phone's going to start ringing. Construction is going to stop. The real estate manager is going to start yelling at you. And then you're going to say, fix this, fix this, fix this. And you don't want those headaches. Trust me, you don't want to keep you awake at night. You know, construction costs, I've seen sites before that, you know, even though it's a good site, you get it zoned, you know, the cost to build the road and the switchbacks and to maintain it sort of defeated the site. I've seen sites like that down the coast because the foundation costs were 3 times what they would normally would be, and the ROI model just got destroyed. But that might be beyond the scope of drafting the lease, but just be aware of those issues. You know, make sure that the final survey has the, you know, the correct nomenclature. You know, whatever the defined terms are in your lease document, make sure those same terms are utilized in the survey. For example, if it's lease premises, show the lease premises. If it's an ingress, egress, and utility easement of 25 feet in width, make sure it says that. The zoning issues and compliance, you know, make sure that your road is of adequate, your easement is of an adequate width to meet the zoning requirements. You know, they have these issues too sometimes about having an area where fire trucks can have adequate ingress and egress and a turning radius at the tower site, which dictates that the access easement width, a parking area adjacent to the tower compound is modified and made larger, if you will, to meet the fire code. There's all kind of traps out there. You got to do your homework to stay ahead of it all. If you are crossing other properties, I sort of skipped over this, get an easement signed by every property owner that road crosses. That way you've got insurance. You might have to pay them some money, but that's okay. You don't know how many times I've had to travel to sites and knock on people's doors to get them to agree just to talk to me to do an easement and for me to explain to them and then negotiate how much money they were going to get. If you do have to pay them, make it a one-time payment, not a recurring payment. So I think I've covered most of this, but
Do you want to go into like permitted uses? I think we kind of covered most probably everything on
the yeah. I'll just say really quick on utility easements. You know, you don't know what you don't know. Make sure you draft these open-ended for future technologies. And don't always assume that the utilities are going in the same easement as the access easement. In some instances, there's a point of presence of fiber and or electricity that's closer from another viewpoint, if you will. So you may have to get a separate utility easement or multiple utility easements, as well as an access easement. And just make sure your easement language is written broadly enough to encompass everyone, tower owner, the carriers, subtenants, whoever. I can't tell you how many headaches we had when the carrier started deploying fiber to the tower sites. I mean, none of the old leases contemplated fiber coming in there, and the fiber companies, they didn't want to touch it without an easement, and it just became very complicated. Anyway, so permitted uses, this is important. Always consider future uses. You know, we don't know what we don't know. You know, sometimes we go and put in specific permitted uses, but I would say if you do that, still have an open-ended use clause in there. You know, make sure that these uses, if you're a tower company, make sure the uses are applicable to the subtenants carriers as well, or vice versa, and not one or the other. Make sure your technology is agnostic. Like I see all these leases that refer to cellular. I see all these leases that refer to PCS. Well, what does that even mean anymore? You know, the spectrum is so broad in terms of the technologies that all of the carriers are using today that, you know, don't be that specific. Some of the things that I would reference you to for uses we never contemplated that I've run across lately are like ground-based microwave stations to communicate with high and low orbit satellites. That's the thing. Do you know that? Yeah. Edge computing, hub sites for a series of small cell clusters, or for outdoor DAS, alternative energy equipment, energy storage. That's a thing now too. Battery sites, mini electrical substations, temporary cows, or just a point of presence or POP for a third-party fiber provider. This is new, airspace for drone surveys. We always say lease to the stars. And somebody corrected me. I said lease to the sky. Somebody corrected me online. I said, no, we lease to the stars. I'm like, you're right. But that's true. There have been lawsuits about people using airspace to use drones for aerial viewing of towers. And I know you think that's crazy, but that's not even the beginning of the list. That's just an example of why you need to keep it open-ended. Make sure you always have an ancillary use clause, which would mean, something ancillary use, but future clauses that say, like, whenever you say what your permitted use is, and you say also now and in the future as deemed necessary. That way you've got everything covered, and you should be fine there. Exclusivity clause, if you're a tower owner, you probably want to put an exclusivity clause in there that the property owner can build another tower on the property. Make sure that there are not any consent requirements for future mods, either on the ground and or the tower if it's a lease. No limitations. Make sure you've got the right head generators and backup power. Don't limit yourself in terms of the type of tower you can build or the number of towers. There are all types of tower farms on the tops of mountains that generate millions of dollars of revenue. If they were limited to one tower, that would have never happened. Term and renewal term, I've been doing this so long, 30 years, that a lot of the early leases I drafted are terming out or have termed out. I probably get, 3 calls a week from a property owner that has been approached by the current owner of the tower, wasn't the current tenant, wanting to renegotiate the term of the lease. And I do that. Sometimes I do it for free. If it's grandma, sometimes I charge a fee for that. But, obviously we got it wrong at the beginning. Most of the leases were like 5 years or 4 or 5 year renewals, 25 years. And then maybe they rolled over automatically for 1 year renewals unless either party terminated. I think a good term today would be 50 years and 5 year increments. You don't really want to go longer than 50 years because in some states, there are certain laws that state that to the extent the lease extends a certain period of time, it's treated more as a conveyance of a greater interest into the property, like a fee, partial fee transfer, which then subjects you to additional property taxes and transfer tax fees, which you want to avoid. Make sure the terms are auto renewal. You never want to have a lease expire because you forgot or the computer system forgot to send out the renewal notice, or the notice address has changed and it wasn't picked up and sent to the wrong address. So make sure there are auto renewals in there. You don't ever want the renewals to be mutual, non-renewals to be mutual. I remember people are smarter today about towers because, they've seen more of it. They've talked to neighbors that have tower leases, and they don't ask us as often, but in the early days, they would say, what do you mean you want the right to terminate every 5 years? Well, I want that right too. Well, you have to explain to them, well, we need that right to terminate because, this is a dynamic network and sometimes some sites become obsolete or unnecessary. Very rare. I can't remember terminating a lease. I do now, but back then I did it. But we can't give you that same right. We can't afford to spend $1 million in infrastructure costs and have you come back to the table 5 years from now and want to renegotiate the rent and extract, a huge sum from us to be able to extend the term. So yeah. So at the end of that term, like I said earlier, have those automatic 1 year auto renewals. But one thing I'm seeing now every day is on these near-term leases, or any lease for that matter, any landowner out there that has a lease is being contacted at least 5 times every month by 5 to 10 different companies. Some of them are legitimate investors. Some of them are not. They're brokers just looking to get like a letter of intent or an option to buy that lease, and the income stream generated from the rent paid by the tenant, and then they go out in the open market and try to sell it at a higher number, and they get the spread, which I think is unethical. I don't like that at all. I try to protect people from those kind of situations. But there are some good companies out there that are willing to pay a good price for that income stream, and they're not really looking to fleece anybody on the front end or the back end. Sometimes it's hard to tell who the sheep are and who the wolves are. Just want to have to sniff around a little bit until you figure it out. But even then, the early Unisons of the world got all bought by the tower companies. It's not even the same investor group that owned them in the beginning. And they're like cannibals too. Even the tower companies are cannibalizing each other's sites in that fashion. So anyway, enough about term. Rent increases. The carrier is getting cheaper and cheaper every day, right? And they don't want to pay high prices on dirt. They don't want to pay high prices on colos. They're trying to reset their MLA pricing. Always try to negotiate a good rent, but be fair. Try to know what the market is. Don't get the lease signed by giving too much rent. Just give them a signing bonus, a one-time signing bonus. Negotiate the lease. One thing I used to see with people that were lazy was, okay, well, I'll just pay them more rent rather than negotiate this legal issue. Don't buy a resolution. Be wise, know what your compromise positions are, and negotiate the legal issues. Avoid revenue shares at all costs. Avoid paying increased rent based on CPI calculations. Have you ever done a CPI calculation before? And do you know how many different formulas there are out there to do it? And you know what I'm like?
Thinking about it.
I know. And that's the easiest way to get your client calling you up and yelling at you is to agree to do that. ACH payments are a big thing now. Get the ACH payments set up so that it's automatic and the company doesn't have to send that check. They're sending out 60,000 checks a month. They don't want to have to write 60,000 checks. They want it automatically done. They post the rent roll and it's processed by the bank automatically. Monthly versus annual payments. For cash flow reasons, a lot of carriers or tower companies, they want monthly payments. Some companies that are flush with cash, they don't want the administrative burden of writing 12 checks, paying 12 times. They just rather do a one-time annual payment on commencement, on the anniversary of the commencement date. Rent increases. This has been a controversial issue as well as the carriers tighten their belts. I've seen some carriers where the number starts at 0 from the negotiation. Anything over an annual 2% increase has got to go to an executive director to be approved, and he may not, or she may not. And they definitely don't want these 15% every 5-year renewal terms anymore. That's way out of they prefer 5-year renewals or rent increases, and if there has to be one, they want it to be low, not 5, 10, or 15%, but low.
Move on to mods and alterations if we can, Gary. We're just running short on time.
Sorry. Yeah, we are.
All right.
Modifications, this is simple. If it's a ground lease, you want to be able to do anything in there that you want to do if you own the tower, right? On the tower and the ground, you don't want any kind of consent issues. Co-locations, this is the battle that the carriers fight with the tower companies every day. The tower companies want incremental rent increases every time you touch a tower, and they never go down if you take anything off. The carriers, they want, to be able to do whatever they want to do on the tower when they want to do it for no money. And some carriers are negotiating BDS, build-to-suit agreements, with a large bucket of rights, if you will, that they can use on that tower before the rent goes up. So yeah, never pay for a frequency addition or change. We see in the news where the carriers are buying new frequency or directly from the FCC auction process or from other carriers like US Cellular. Make sure that there's an approval standard in the lease. If consent is required for mods, make it a reasonable standard. Put time limits on there. you don't want somebody holding you up on your rollout of your next generation of wireless technology because a landlord won't respond to your request. I've seen that happen. You might be able to put in a deemed approved. So if they don't respond in 30 days, the lease says the request for the modification is deemed approved. So the struggle continues, and it always will. Assignment rights, very big. If you're the tenant, you want to make sure that you've got as much assignability as possible. I mean, we all know that who've been in this industry, these leases change hands so many times. They hardly ever stay with the same tenant forever. So make sure that you've got as much flexibility to assign the lease without consent, and that you're going to be released upon that assignment as well. You don't want to be paying charges like some landlords want to pay an assignment $2,500 plus you're paying our legal fees. Don't agree to that. And no profit sharing if there's a rent increase. And if you can, you don't want a prior notice requirement for assignment. And a lot of these bigger deals, there might be limitations or confidentiality requirements in the asset purchase agreement, or there may be, if it's a publicly traded corporation, there may be some SEC rules and regulations that would prohibit prior notification of a landlord of the transaction. So be careful there. Subleasing rights, same thing. Make sure that you've got, it depends on the agreement, but make sure you've got the right to sublease without paying a rev share, without consent. But make sure that you deserve the discretion to sublease, because you don't want the property owner dictating who you sublease to and who you don't sublease to. Reserve the right to do government subleases for free if necessary. We've all used that card at zoning hearings before. So that's probably enough. You can see my contact information there. Please feel free to reach out to me at any time if you have a question about these terms or any potential term or transaction that you're working on and you're stuck. There's my email address, telephone number. If you would like a copy of today's presentation and the longer version, if you will, please feel free to reach out to me. I'll share it with you for free. Follow me on LinkedIn. You see the LinkedIn square there. I'll share information online a good bit. I've been a little lazy the last couple of weeks, but I plan to get busy again doing that soon. Thank you everyone for your attendance today, and hopefully you're still listening and not asleep, and that you've all learned something. If we're not friends, then connect with me on LinkedIn and we'll become friends. Thanks, Jeremy. With that, I'll conclude.
You got it. Thanks, guys, everybody. Just so you know, this version of this, it'll be recorded and uploaded like the TXWA, website. I want to thank Gary for coming in today. It's a lot of information to digest in a short amount of time, but here we're trying to give some value to some people that may not have seen this stuff before. If you got questions, like Gary said, feel free to reach out to him. And with that, I think we'll wrap this up. Sorry for going over a minute. This has probably been a longer one, but a lot of good information, a lot of material there. Hopefully somebody learned something today they didn't know. With that, we'll wrap this thing up, and have a good afternoon, guys. Appreciate your time.